Shop the Sherwin-Williams Labor Day sale and get 35% off paints and stains August 22nd through September 4th. With prices starting at $31.84, it's the perfect time to transform your space with color. Whether you're looking to revamp your interior or exterior, we have you covered with bold hues, soothing neutrals, and everything in between. Visit your neighborhood Sherwin-Williams store or shop the sale online. Delivery available on qualifying orders. Click the banner to learn more. Retail sales only. Some exclusions apply. See store for details.
Imagine this scenario. You're a peace officer. Things are chaotic shouting, maybe flashing lights, just pure adrenaline. And your partner, maybe 10 yards off, is down, locked in a really bad fight.
Okay.
There's a suspect over them, about to kick them in the head. Could be deadly.
Right. High threat.
But here's the twist. Between you and your partner, there's a 10-foot chain link fence.
Wow. Okay. An obstacle.
Exactly. You're armed. Taser, OC spray, pistol, baton, all there.
Yeah.
What do you do? I mean, that's a split-second decision, right?
Absolutely. Incredible pressure.
How do you even assess that? Weigh the options, act, knowing the huge consequences of whatever you choose.
Yeah, that's the core of it.
And this isn't, some Hollywood script. It's a real training scenario.
It really drives home the gravity, doesn't it?
It does. It just throws you right into the complexity of use of force decisions.
Yeah.
So today, on the deep dive, we're plunging right into these critical, often instantaneous choices officers make. Our mission here is to give you, our listener, a real solid understanding of the legal side, the psychological factors, the practical stuff.
All of it.
That govern these actions. And we're drawing directly from the training materials, the actual case law that guides officers day to day.
Which is crucial context.
Definitely. And look, we're not here to take sides. This is about understanding the multifaceted reality of these incredibly high-stakes situations. It's about grasping that intricate dance between law, human behavior, and, public safety.
And it's exactly that kind of scenario that just highlights the profound weight of this whole topic.
Right.
What's really striking, I think, is that we're discussing situations where lives, officers, suspects, bystanders can genuinely change forever in a heartbeat.
Instantly.
Yeah, instantly. And the ethical lines, they aren't static. They're constantly being defined, argued over, refined in courtrooms and communities.
Always evolving.
Always. And the decisions made in those moments, they carry just immense responsibility, not just for the officer, but for everyone they serve. So having a clear, informed perspective, it's absolutely crucial to grasp the real impact.
Okay, so let's unpack this then. Before we get tangled up in specific scenarios or the stress psychology or the legal nitty-gritty, we need a common language.
Agreed. Definitions first.
Because when we hear use of force, most people, myself included, probably jump straight to physical contact, maybe a weapon.
That's the common perception, yeah.
But legally, it sounds like that definition is way more nuanced. What exactly do we mean by force? And maybe more importantly, deadly force in the eyes of the law? Because I'm guessing they're not just everyday words.
You're absolutely right. They carry very specific legal weight. And the definition of just force, it's surprisingly multi-layered. Black's Law Dictionary lays it out, and it's much broader than just like a physical fight.
Okay, how so?
Well, as a noun, first off, force can mean strength or energy brought to bear, active power. Think about an officer's professional presence, that sort of commanding, controlled vibe they project arriving on scene.
Yeah, just their bearing.
Exactly. It's not physical, but it's a kind of moral or mental strength, a capacity to persuade, maybe convince someone to comply. That's a type of force.
Huh.
Then, of course, it also means violence, compulsion, or constraint exerted upon person or thing. That's the more physical aspect we usually think of.
Got it. What about as a verb?
As a verb, force means to compel by physical, moral, or intellectual means.
Okay, compel.
Yeah. So an officer giving a loud, clear command, stop, put your hands up, they're actively using force, intellectual and moral force, to compel compliance. It's meant to achieve an objective.
Right.
It can also mean, and this is interesting, an aggressive act, which does not amount to assault and is necessary to accomplish an objective.
Aggressive but not assault. How does that work for police?
It's a crucial distinction for law enforcement. An officer confronting someone, taking initiative, acting decisively. It's not aggression in the hostile or criminal sense. Their actions are designed to defend and protect the community. to achieve a legitimate goal, like making an arrest. So it's about controlling a situation necessarily, not just initiating violence for its own sake.
Okay, so force covers this whole spectrum. Presence, commands, physical control. But then there's deadly force. That sounds obviously much more severe. How is that specifically defined? What's the bright line there?
Yeah, when we talk deadly force, the Texas Penal Code PC Section 9.01 subsection 3 gives us a very precise, very critical definition.
Okay.
It is force that is intended or known by the actor to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury.
Okay, intended or known or capable of causing. Those seem like key parts.
They are paramount, absolutely. First, intended or known by the actor. That focuses on the officer's mindset, right? Did they mean for their action to cause death or serious injury, or did they know it was highly likely to?
Subjective, almost. What was in their head?
To a degree, yes. But then the second part, maybe even more significant, is capable of causing. This means it's not just about the actual outcome in that specific instance. It's about the potential of the action itself.
Ah, right. So firing a gun at someone's chest.
Exactly. That action is inherently capable of causing death or serious bodily injury, period, regardless of whether the bullet actually hits a vital organ or misses or whatever.
Gotcha.
And the Supreme Court actually touched on this idea in Scott v. Harris. That was a Georgia case, decided 2007. They said there's no magic on-off switch for what is considered deadly force.
So it's not black and white.
It implies more of a spectrum, yeah, where actions can kind of become deadly force based on their potential, the context. It really emphasizes the gravity of the decision before a weapon is even fired.
That distinction, intent versus potential in deadly force, that's critical. It's not just the result, it's the risk being created.
Okay.
So taking all this general force, deadly force, how do courts then decide if an officer's actions were, appropriate? What's the standard they use?
Well, building right on those definitions, we get to the absolute cornerstone for evaluating police actions, reasonable force.
Reasonable force.
Okay. And the definition is the amount of lawful physical coercion sufficient to achieve a legitimate law enforcement objective. Okay,
Sure.
that makes sense. And is objectively reasonable under the facts, circumstances, and alternatives confronting an officer at the time actions are taken.
Objectively reasonable. That sounds like the key phrase.
It is the operative phrase. It means we're not judging the officer based on their personal feelings, their subjective beliefs, maybe even their good intentions.
Right, not what they thought, but...
But what a reasonable officer with similar training, similar experience would have done in the exact same situation, given only the facts known to them at that precise moment. It's an external standard.
Okay.
And it crucially emphasizes considering alternatives. Were there other viable, less forceful ways to achieve that legitimate objective?
Right, could they have done something else?
Exactly. And this whole concept of objectively reasonable, it's absolutely central. It's how courts, juries, the public, everyone assesses an officer's actions. And it brings us right to a really landmark Supreme Court case that codified this whole standard.
Objectively reasonable. It sounds like common sense on the surface, but applying it to split-second decisions under massive stress, wow, that must be incredibly complex.
Absolutely.
You hear critics say it gives officers too much leeway. Others say it's the only fair way to judge. How did the Supreme Court, in Graham v. Garner, try to give us a clearer filter for this? And why was that shift away from the officer's intent so important?
That's precisely the tension, isn't it? And Graham v. Garner, back in 1989, tackled it head-on. The case involved D. Thorne Graham, a diabetic having an insulin reaction.
Okay.
Police in Charlotte, North Carolina mistook him for being drunk. His friend tried to explain, tried to give him orange juice. Graham asked them to check his wallet for a diabetic decal. The officers refused.
Oh.
A struggle happened. 4 officers threw him headfirst into a police car. He got serious injuries, sued.
Understandably.
Alleging his rights were violated. The lower courts initially sided with the officers, using the old 14th Amendment standard, basically. Did the officers act with malice? Did they intend to harm him?
The absence of malice thing.
Exactly. But the Supreme Court said, no, that's not the right lens.
So why did they shift? Why move from intent to what a reasonable officer would do?
That was the huge question. The court ruled that all claims of excessive force during an arrest, a stop, any seizure of a person must be analyzed under the Fourth Amendment's objective reasonableness standard.
Fourth Amendment, not 14th.
Okay, right. The court explicitly said the question must be whether the officer's actions were objectively reasonable in light of the facts and circumstances confronting them at the time, without regard to their underlying intent or motivation.
Without regard to their intent. That's the key change.
Monumental shift. Moving away from the officer's internal subjective state, I meant well, to an external objective standard. What would a rational, trained officer have perceived and done right then?
Okay, so how do we apply that? Did the court give any guidelines?
They did. To help apply this objective reasonableness, the court laid out what we now call the Graham factors, 3 key factors for evaluating any use of force incident.
Okay, the Graham factors. What are they?
First, the severity of the crime at issue.
Makes sense.
Yeah.
Minor traffic stop versus, say, armed robbery.
Exactly. Logically warrants different levels of force. Second, whether the suspect poses an immediate threat to the safety of the officers or others.
The threat factor. That seems huge.
Often the most critical one, yes, is someone's life or physical safety in imminent danger. And third, whether he is actively resisting arrest or attempting to evade arrest by flight.
Resisting or running.
Yeah.
Okay, severity, threat, resistance, flight.
Those are the core 3, but it's also absolutely vital to understand the context the court wrapped around them.
Right.
They stressed looking at the totality of circumstances, acknowledging that these situations are almost always tense, uncertain, and rapidly evolving.
Real life isn't neat.
Not at all. And maybe most importantly, no 20/20 hindsight.
Meaning
Meaning we simply cannot judge an officer's split-second decision from, the comfort of a courtroom or an armchair with perfect information all the time in the world to analyze.
right. You have to put yourself in their shoes at that moment.
Precisely. Decisions made in fractions of a second under immense stress have to be evaluated through the lens of what a reasonable officer on the scene would have perceived and done right then. Understanding these factors lets you, the listener, see how courts wrestle with these incredibly tough moments. Trying to balance the need for decisive action with constitutional rights, it really calls for empathy even while demanding accountability.
Okay, so we've got the basic definitions: down force, deadly force, and the Graham factors as the filter for objective reasonableness. That's a solid framework.
It is.
But for an officer out there, that framework needs a legal backbone, right? What are the actual laws, the statutes that allow them to use force in the first place?
Good question. They need that authority.
And just as importantly, what legal protections, like this qualified immunity we hear about, do they have or not have when they end up facing lawsuits after these incredibly intense decisions?
Right, the authority and the potential shield. You're hitting on the crucial legal scaffolding. The Texas Penal Code, the PC, provides several sections that act as the fundamental legal authorities for using force. Think of it like a rule book of justifications.
Okay, like what?
Well, PC 9.02 gives justification as a defense, meaning if an officer's force falls within these legal lines, it can be a defense against criminal charges.
Makes sense.
PC 9.03 covers confinement as justifiable force, relevant for detention, restraint. PC 9.04 deals with threats as justifiable force, acknowledging that even threatening force, like drawing a weapon without firing, can be necessary and justified.
Okay.
What's really interesting here is the law even acknowledges potential mistakes. PC 9.05 covers reckless injury of innocent third person. So if justified force unintentionally hurts a bystander, there are specific legal considerations.
Accountability even then.
Yes. And PC 9.06 clarifies that civil remedies are unaffected, meaning criminal justification doesn't automatically block a civil lawsuit. That's a key distinction.
Right, criminal versus civil.
And finally, PC 9.51 specifically addresses force used during arrest and search, laying out the basis for using force while doing those fundamental duties. So it's a pretty detailed framework underpinning their actions.
That seems comprehensive for when force is allowed.
Yeah.
But what about the protection side when lawsuits inevitably happen? This qualified immunity idea keeps popping up. What exactly is it? How does it actually work in practice?
Right, the protection piece. Qualified immunity. It's a really key and often really debated concept for government officials, including police officers.
Okay.
It's a legal defense. It can shield them from liability for civil damages under federal law, but only under certain conditions. It's not absolute immunity. It's qualified.
Qualified, meaning it has limits.
Exactly. The case, Milstead v. Kibler from the Fourth Circuit back in 2001, laid out a common 3-part test for it. To get past qualified immunity and sue an officer, a plaintiff has to show three things.
Okay, what are they?
1, did the officer's conduct actually violate a federal right, constitutional or statutory? If no violation, case over.
Simple.
2, was that specific right clearly established at the time the conduct occurred? This is often the big hurdle.
Clearly established. What does that mean practically?
That's the crucial question. It's not enough for a right to just exist generally. The Supreme Court says its violation has to be so obvious that any reasonable officer would have known they were breaking the law.
So there needs to be prior case law on basically the same situation.
Essentially, yes. Existing case law that would have put a reasonable officer on notice that their specific conduct was unlawful in those circumstances. And third, part 3 of the test. Would an objectively reasonable officer have understood that their conduct violated that clearly established right?
Okay, violation, clearly established, reasonable officer knew.
That's the gist. Oconco v. Fernandez, a Texas case from 2003, reinforced this. Officials get immunity if their conduct doesn't violate clearly established rights a reasonable officer would know. And importantly, the official has to affirmatively plead this defense. It's not automatic.
They have to raise it themselves.
Yes. Anderson v. Creighton from 87 also stressed this clearly established part, focusing on what a reasonable official would know. And Saussure-Katz in 2001 set up a two-step inquiry. First, was right violated? Then, was it clearly established? It really highlights the legal tightrope officers walk upholding the law while trying to stay shielded from liability.
So, qualified immunity is a strong shield,
Right.
but it hinges on whether the right violated was clearly established. Let's zoom in on deadly force again within this legal world. Are there even stricter rules or specific cases governing when an officer can use lethal force?
Oh, absolutely. For deadly force specifically, there are very clear precedents that have really shaped modern policing. One powerful example is the state of Zabalios v. Bridgewater, Porras, and Mole. That's a Fifth Circuit case. It states very clearly, an officer cannot use deadly force without an immediate threat to himself or others, plain and simple. And that lines up directly with PC 9.51 on arrest force. The threat has to be imminent and serious.
Immediate threat.
But if we connect this to the really big picture, the landmark Supreme Court case is Tennessee v. Garner from 1985. That case fundamentally reshaped when deadly force could be used.
Good Garner. That's the one about fleeing felons, right?
Exactly. Before Garner, in many places, it was often legally okay to use deadly force against any fleeing felon just because they were a felon trying to escape.
Wow.
Garner involved Memphis police shooting and killing Edward Garner, an unarmed 15-year-old, fleeing a burglary. The officers argued they were following state law allowing all necessary means to effect the arrest.
Okay.
But the Supreme Court ruled that the Fourth Amendment prohibits using deadly force against a fleeing felon unless that person poses a significant threat of death or serious physical injury to the officer or others.
So just fleeing isn't enough anymore. They have to be dangerous.
Precisely. It was a monumental shift. It dramatically changed the standard from simply fleeing a felony to requiring a clear present danger to life or safety. Garner essentially said human life is more valuable than just catching a nonviolent fleeing suspect. It's a cornerstone of modern use of force policy.
Okay, so we have the legal definitions, the Graham factors, the Garner limits on deadly force. That's the foundation laid.
Right. The core principles.
Now, let's explore the specific situations where force is legally justified, and maybe look at some actual cases. Because that's where these abstract ideas really come alive, right? Seeing how they play out in the messy real world.
Indeed. It's one thing to know the rule, another to see it applied. Beyond the arrest and search statutes, the Penal Code gives a whole range of justifications for actions by anyone, officers included, in certain situations.
Like what kind of situations?
Well, generally there's public duty, PC 9.21, and necessity, PC 9.22. These cover times when an officer acts to prevent a greater harm or just fulfill their official duties. Basic responsibility stuff. Then you get into specific justifications for the protection of persons. That's PC 9.31 through 9.34.
Self-defense, presumably.
That's in there, yes. PC 9.31 covers self-defense, but it goes much further. PC 9.32 allows deadly force in defense of person, outlining when lethal force is okay to protect your own life or prevent serious injury.
Okay.
What's really striking here is it extends even further. PC 9.33 covers defense of third person, so an officer can use force, even deadly force, to protect someone else who's in immediate danger.
Protecting others, not just themselves.
Exactly. And PC 9.34, protection of life or health, gives a broad justification for actions to prevent serious injury or death to anyone. The key insight, I think, is how broad that scope of protection can be. It's not just the officer's safety. They're constantly calculating how to protect bystanders, victims. It massively amps up the pressure.
I can only imagine. What about property?
Yep, there are justifications for protection of property, too. PC 9.41 to 9.44. This includes protecting your own property, using deadly force to protect property, but only in very specific, limited circumstances like stopping arson or serious theft.
Okay, very limited there.
Very. And protecting a third person's property. There's even a bit about using devices, like security systems, to protect property within limits.
Any other categories?
Yeah, the law also recognizes special relationships. PC 9.61 to 9.63. These are pretty unique. Parent-child, educator-student, guardian and competent.
So how does that factor in for an officer if they're also a parent dealing with their kid or maybe an educator involved in a student incident?
It raises that important question, right? The law provides a framework for justified force within those very specific contexts, acknowledging the unique responsibilities and authorities that come with those roles. It's another layer of complexity. And finally, justifications related to custody and escape. PC 9.52 and 9.53. Preventing escape from custody, maintaining security in jails or prisons, giving officers the authority they need there.
Okay.
And just to tie it back to civil court, justified use of force can also grant civil immunity. The Civil Practice and Remedies Code, CPRC 83.001, says if force is justified under Penal Code Chapter 9, the person using it is immune from civil liability for injury or death that results, a shield if the actions were legally sound.
That's a comprehensive map of justifications. Now, let's make it real. Turn these principles into actual situations because the sources you mentioned have examples, right? Cases where courts looked at these specific actions and made rulings.
Oh, yeah. Plenty of examples that show how courts grapple with this stuff. Let's start with deadly force cases since those get the most scrutiny.
Okay.
Frere v. City of Arlington from 92. It's more general use of force, but sets a context, emphasizing that totality of circumstances.
Right.
Then Brother v. Clavenhagen, a 94 Fifth Circuit case. This one okayed deadly force when a vehicle was driven at an officer.
The car as a weapon.
Exactly. If we connect that to the bigger picture, it really highlights the immediate lethal threat a vehicle can pose. The court recognized that.
Big sense.
Similarly, Hathaway v. Bazzani, 2007, also Fifth Circuit, involved shooting at a moving car after an officer was struck by it. Again, underscoring the danger from vehicles. These cases show immediate threat isn't just about guns or knives.
Okay. What about non-deadly force examples? Tasers?
Good examples there, too. City of Waco v. Williams, 2006. Taser used during an escape attempt from a sally port that secured entryway in a jail.
Right.
It raises that important question. What's appropriate taser use, especially during an active escape? The court had to weigh the escape risk against the force used.
Tricky balance.
And Jackson v. City of Schertz, 2007, another taser case, shows the ongoing scrutiny. These often hinge on whether the taser was used against active resistance or threat, or just, say, verbal noncompliance.
What about even less severe stuff, like handcuffs? Can that be an issue?
Surprisingly, yes. Baskin v. Smith, 6th Circuit, 2002. The issue was handcuffs that were too tight. Not double lock.
Seriously, too tight?
Yeah. What's insightful is how even seemingly minor things like cuffing can become a legal problem if done wrong. Causes injury, pain, lawsuits. Officers are trained to double lock cuffs so they don't keep tightening and cause nerve damage.
Wow. Okay. Pepper spray.
Also highly scrutinized. Martinez v. New Mexico Depth of Public Safety, 10th Circuit, 2002. Pepper spray used on someone already handcuffed, but who was verbally non-compliant.
So already restrained, but still got sprayed.
Right. Highlights the debate. Does just being mouthy justify chemical agents when you're already cuffed? Then there's Jennings v. Jones, 1st Circuit, 2007. This one's really interesting. Also a verbally non-compliant subject, but the force wasn't pepper spray, it was an ankle lock.
Ankle lock instead.
Yeah, shows how specific the court's focus can be, analyzing the exact type of force and its justification. Even non-lethal physical holds have to be objectively reasonable.
Okay. What about just pointing a gun? Is that force?
It can be considered force, and it gets examined. Robinson v. Solano County, 9th Circuit, 2002, involved a seizure at gunpoint. The ruling was basically confinement reasonable, force not.
So they could stop the person, but pointing the gun was too much.
In that specific context, yes. It's a critical distinction. The initial stop might be legal, but the amount or type of force used during it might not be reasonable.
Fascinating. What about canine units? Dogs.
Powerful tool, very debated. Kuha v. City of Minnetonka, 8th Circuit, 2003. Use of a canine resulted in a groin bite. Ooh. Yeah, that leads to intense scrutiny. How was the dog deployed? How long is the
Yeah.
bite? Where was the bite?
Right, but wasn't there another case where a bite wasn't deadly force?
Good memory. Robinette v. Barnes, 6th Circuit, 1988. A canine bite to the neck of a burglary suspect was not deemed deadly force in that case.
Neck bite, not deadly force.
It caused a lot of discussion. Shows that whether a canine bite is deadly force is highly contextual. Depends on the specifics, the dog's training, the target area. So what does this mean for canines? It's a spectrum, and courts look at the intent and the outcome.
Okay, last one. This hog tie or hobble tie thing, that sounds controversial.
Very controversial, and for good reason. Cruz v. Laramie, 10th Circuit, 2001. The 10th Circuit actually forbade using it when combined with factors like the subject having diminished capacity. They recognized the heightened risks.
Risks like what?
It can severely restrict breathing, especially for people under duress or with health issues, positional asphyxia.
Right.
And Morris v. Dillard-Depstore, 5th Circuit, 2001, involved a tragic hog tie asphyxiation incident, further highlighting the serious risks. These cases really show the incredible detail courts go into, scrutinizing every level of force, even restraints. Shows how vital it is for officers to understand the physiological impacts of their actions.
Wow, those case examples really drive home the weight of these decisions. But beyond the laws, the precedents, there's that huge human element, right?
Absolutely crucial.
What is actually going on inside an officer's head during these incredibly tense moments? How does their psychology, their training, influence those choices when they have, like, fractions of a second to act? It must just be an overwhelming mental landscape.
You've hit the absolute core challenge of policing right there. This is where abstract law slams into immediate human response. Fundamentally, the law enforcement role in an arrest situation is essentially defensive.
Defensive. How so? They're usually the ones initiating contact.
Good point. But defensive here means serving to protect, or resisting or preventing aggression.
Okay.
It's crucial to understand that an officer confronting a law violator, even though they're taking initiative, being assertive, it isn't legally viewed as hostility or aggression in the criminal sense.
Right, it's their job.
Exactly. Their action is designed to defend and protect the community from criminality. But problems often crop up when reasonable alternatives aren't used against someone who's maybe combative but unarmed.
Which brings up that question again. How does an officer figure out what's a reasonable alternative in real time, under pressure, things moving fast?
Yeah, that's the million-dollar question. Central to managing this is the concept of control.
Control, meaning controlling the suspect.
Yes, but it's defined as that degree of influence the officer must exert over the violator to take him or her safely into custody. And critically, it's seen as a two-way street, meaning an officer has to maintain complete self-control to effectively control a violator. Self-control is one of their greatest assets.
And that comes from?
Confidence in their skills, which comes from rigorous training, practice, repetition. The ultimate goal of using control, physical, verbal, even just presence, is always to get cooperation, ideally using the lowest level of force possible.
Okay. Self-control is key.
Yeah.
What else affects their mindset?
We absolutely have to consider emotions, attitudes, and prejudices. An arrest is inherently emotional and physical for both sides.
Sure.
An officer's emotional responses, maybe unconscious biases, attitudes, prejudices, they can unfortunately escalate conflict very quickly.
Yeah.
But conversely, a well-trained, emotionally intelligent officer has the potential to reduce danger by being, as the training says, firm but fair.
Finding that balance.
Right. And it's important to realize that many emotional responses, especially negative ones like anger or frustration, often stem from uncertainty.
Uncertainty about the situation.
Yeah. And uncertainty often leads to what's called compensating behavior. Things like hesitation, maybe verbal abuse, bluffing, or even, tragically, unnecessary force.
Stress makes people react poorly.
Exactly. What's insightful here is how stress and uncertainty can push even well-meaning officers down bad paths if they haven't developed that self-awareness, emotional regulation, and practiced control.
So when they're facing a situation, what factors do they consider, consciously or subconsciously, before using force?
They're running through a rapid checklist, basically. Things like, is the suspect submitting peacefully, or are they actively resisting? Big difference. Is the suspect armed, or do they appear armed? That immediately changes the threat calculus. What's the nature of the crime? Violent felony versus misdemeanor. Does this person have a known history of violence? Context matters. How many suspects are there? How many officers? Safety and numbers. And crucially, what's the risk my actions could injure a bystander or another officer? Priority of life.
And you can see how those practical on-the-street things line up almost directly with the grand factors we talked about earlier.
Absolutely. Severity of crime, immediate threat, resisting fleeing. It directly connects operational decisions to the legal standard, right there in the moment.
It's so clear that the mental game, the training, is just as vital as knowing the law. But what specific tools, what mindsets are officers actually given to navigate these incredibly high-stress moments, to make sure they're making the right call, not just physically but cognitively, in that blink of an eye?
Right. It's about performance under pressure. That's where the science of vision and reaction becomes incredibly important.
Vision and reaction.
Yeah. What we look at, how we actually perceive things under stress, and how we react, it can literally make the difference between life and death. Officers get rigorously trained on how vision works under stress.
Like what?
They learn about foveal vision. That's a really narrow, 3-degree cone. It's what you use for precise focus, like getting your sights lined up on a target. Takes about a quarter second once the sights enter that cone.
Okay, narrow focus.
Then there's parafoveal vision, a wider, maybe 10-degree cone, gives you peripheral info. Now, a common issue for novices under stress. They look away from the threat, down to their sights.
Losing sight of the suspect's hand.
Exactly. Experts learn to focus only on problem areas, head, hands, elbows, especially from behind, because if the elbows move out, the hand is likely coming up.
Ah, okay. Tactical awareness.
Right. And getting the pistol into the eye line quickly is key training. Maximize efficiency and maintain visual on the threat.
Makes sense. What other mental tools?
Another critical one is preloading.
Preloading, like loading a gun.
No, loading the brain. It's selective attention combined with pre-planned responses. If X happens, I will do Y.
Okay, scenario planning in your head.
Exactly. An officer might mentally rehearse, if he reaches for that bulge in his waistband, I will. Or if he charges, I will immediately move, create distance, draw.
Oh, got it.
If we connect this to the bigger picture, it's proactive mental prep. Creating conditional responses, so you're not trying to figure out a plan from scratch during the crisis. Building mental muscle memory.
So you react faster, more appropriately.
Precisely. And this leads to what some call thoughtless performance or subconscious action.
Acting without thinking. Isn't that bad?
Not in this context. Think about drawing a weapon. If you've practiced it thousands of times until it's reflexive, doing it actually relieves stress because you don't have to consciously think about the complex mechanics.
Oh, okay. Frees up mental bandwidth.
Exactly. Drawing your weapon on a furtive movement, some sudden suspicious action, and just getting into a ready position, that allows clear vision of the threat, and it's not even considered a use of force itself. Competence with the tools gives officers confidence to make better decisions, using those precious seconds to gather more info instead of fumbling.
Okay.
Even those furtive movements where your brain might jump to conclusions, you have to pay attention until you know what you're seeing. Thoughtless performance helps see through that ambiguity and act decisively.
What about the actual arrest process? Any specific procedures there?
Oh, yeah. Very specific, legally mandated procedures for arrest and frisk.
Frisk first. That's just for weapons, right?
Justified only for weapons, yes.
Right.
Officer safety, public safety. It's a pat-down, not a full search, and the officer needs a reasonable belief the suspect might be armed and pose a threat.
Okay. And the arrest itself?
Clear language is absolutely key. Officers are trained. Tell the person they're under arrest. Tell them why. They're even encouraged to take a moment, explain the process, because sometimes resistance comes from misunderstanding or fear.
Makes sense. Unless
the suspect is clearly using that time to delay, prepare an attack, like backing away, getting into a fighting stance, then immediate decisive action is necessary. No time for talking.
that look into the psychology, the training, it really highlights the immense pressure. So once an officer has processed all that, the law, the threat, their training, they have this range of options, right? This sort of force continuum idea.
That's right. A spectrum of tools and tactics.
Let's break that down. What does that continuum look like, and what does it really mean to use force professionally? Because it sounds like more than just having tools. It's knowing exactly how and when to use them.
Exactly. The spectrum, often called the force continuum, typically progresses through levels, least intrusive to most. Though real life is rarely that neat and linear.
Right. It can jump levels fast.
Absolutely. But it starts with the least intrusive. Professional presence.
It's being there.
Just an officer entering the scene, embodying authority and control through their demeanor, uniform, posture. They teach you only get one first impression, make the correct one. Not about being good, but correct. Projecting competence, command. That alone can de-escalate a lot.
Okay. Level 1, presence. What's next?
Verbal communications, and this is incredibly difficult under stress.
Yeah, trying to talk calmly when your heart's pounding.
Right. Officers are trained hard to avoid coarse, offensive language, even when they're yelling in chaos. Commands need to be loud, repetitive, clear, and simple. Think, stop, freeze, don't move, hands up.
Basic commands.
Basic, clear. Announcing police or sheriff's deputy loudly helps too for compliance and later in court. But what's truly insightful is the physiological impact of adrenaline.
How so?
Stress messes with communication. Auditory exclusion sounds get muffled. Perceptual narrowing tunnel vision. Physical senses get deadened. Time distortion. Chronological confusion later.
Wow. All that makes clear talking incredibly hard.
Exceptionally hard, yet it's paramount. Once control is gained, giving consequences for non-compliance, if you move, I will shoot you, can help suspects understand the stakes. They even practice this stuff because communication is constant and its power is often underestimated.
Okay, presence, verbal. What if that's not enough?
Then officers might move to weaponless strategies, physical techniques, takedowns, come-alongs, control holds, defensive tactics to gain physical control without weapons.
And so on.
Right. Beyond that, weapon strategies, less lethal tools, chemical electrical like taser or OC spray, stun guns, batons, impact weapons, designed for temporary incapacitation or pain compliance.
Less lethal option.
Exactly. And then the last option is deadly force, reserved only for situations with that immediate threat of death or serious bodily injury, like we discussed with Tennessee v. Garner.
Okay, that's the spectrum. How do officers prepare for using these, especially the higher levels?
It requires intense mental preparation. Officers have to be mentally ready to use weapons, and just as importantly, have weapons used against them.
Wow.
Ready to react instantly, ready to sustain injury, potentially, and critically, ready to continue the fight, continue the mission, regardless of personal harm.
That's a heavy mindset.
Yes, and it's not innate. It's built through rigorous training and competence that builds confidence, instinctive reactions, mental alertness, and crucially, emotional control. Connecting this back, training isn't just physical skills or law. It's building mental resilience, that psychological framework to perform under extreme duress.
And guiding these decisions, especially the really tough ones, is there an ethical framework, like who gets prioritized?
Yes, a core principle is the priority of life. The idea is, while we value all life, in deadly force situations, officers have to make incredibly hard choices about who they're protecting from whom.
Okay, what's the usual order?
Typically, the order of priority is, first, victims, then third parties, innocent bystanders, then the officer themselves, and last, the suspect.
Victims, bystanders, officer, suspect. That raises a tough question. How does an officer balance that in a chaotic moment, especially when their own life is maybe third on that list?
It's a constant, agonizing calculus, and the principal considerations in applying force refine it further. Officers aim for effective control.
Meaning?
Well, ineffective control is when the force used is less than the resistance, which can let things escalate. Excessive control is when the force is unreasonably greater than the resistance, causing preventable injury, liability.
Finding the Goldilocks zone.
Kind of. The force should be no more than a reasonable officer would use under the total circumstances, always following policy and law, tailoring the response to the specific evolving reality of that encounter.
So it's having the tools, the training, the mindset all calibrated. But what does it truly mean to be a professional peace officer using force? It sounds like way more than just following a flowchart.
Oh, absolutely. Far more. A professional isn't just following rules mechanically. They're using theoretical knowledge, refined skills, under constantly changing, unpredictable circumstances. There are several criteria for professionalism here.
Like what?
First, the ability to communicate effectively with those persons outside of the profession, explaining actions clearly to supervisors, juries, the public.
Articulation, okay.
Second, ability to accurately assess the situation and define the problem. Getting to the core threat, understanding what's really happening.
Seeing clearly.
Third, and this takes deep judgment, ability to know when to move from words to force. The source material flat out says there's no clear-cut, simple answer here.
The hardest part, maybe.
Could be. And a professional's use of force is both selective, knowing what kind and how much force for that threat, and appropriate, controlled, purposeful, proportional. Fourth, they need the ability to return to words once the threat is over. De-escalation shouldn't stop. Once control is gained, shift back to communication, empathy if possible.
Coming back down?
Exactly. Also, professionals need the knowledge to recognize being under the influence,
Yeah.
or having a mental or physical disorder. Impairment or crisis often needs a different approach than just criminal resistance.
Recognizing vulnerability.
Yes. And finally, the ability to evaluate personal performance and describe it to superiors, being consciously competent.
Consciously competent.
Knowing why you did what you did, able to articulate your decision-making process. What's compelling here is this encourages critical thinking, deep self-reflection, even after intense moments, fostering continuous learning throughout a career.
That emphasis on professionalism, on being consciously competent, that's so vital. But unfortunately, sometimes, despite all the training, the laws, force is used improperly, excessively, and the consequences are severe, often tragic for everyone involved.
It happens, and it's devastating when it does.
So it's not enough to know when force is justified. We have to look at what happens when it goes wrong. The accountability piece. What procedures kick in after, say, an officer-involved shooting? What are the potential liabilities? This is where public trust really gets tested.
Definitely. The aftermath of a serious use of force incident triggers extensive mandatory procedures. Every department has detailed departmental policy for investigations.
Okay.
A key legal protection for officers during these internal probes is Garrity v. New Jersey. That's a 1967 Supreme Court ruling.
Garrity. What did that establish?
It established that evidence gathered from a public employee, like an officer under threat of being fired if they don't answer, that compelled testimony is inadmissible against them in a later criminal trial. It protects their Fifth Amendment right against self-incrimination in the criminal context.
So they might have to talk for the internal investigation, but it can't be used to prosecute them criminally.
Yeah, that's the core idea. It often leads to separate, parallel, internal affairs investigations. If criminal charges are possible, departments run distinct administrative and criminal probes.
It's two tracks.
Right. In the administrative investigation, officers might be compelled to answer, maybe do a polygraph. With that Garrity protection, the info stays administrative, can't be used criminally. But if any answer is intended for criminal use, the officer must be given Miranda warnings first. Protects their rights.
It sounds like a tricky legal tightrope for investigators.
It is. Garrity creates this specific balance, ensuring rights are protected while allowing internal accountability. And this balance is also reflected in state laws, like Texas Government Code Chapter 614, Local Government Code 143 and 158. Specific guidelines for these complex investigations, ensuring due process and accountability.
Okay, so the investigations are complex. But what are the actual consequences if force is found to be improper or excessive? We hear about federal charges, civil suits. What does that really mean for an officer?
The consequences can be career-ending, even life-altering. Federally, officers can face criminal charges under Title 18 of the U.S. Code. Section 241 is conspiracy against rights. Section 242 is deprivation of rights under color of law.
Civil rights violations.
Serious ones. The FBI investigates these, looking for clearly offensive, deliberate, and willful misconduct. Not just a mistake, but intentional abuse of power.
Willful misconduct.
Yeah, sometimes they might defer to local processes if the agency acts quickly and decisively. But crucially, for these criminal violations, there's no good faith defense. Saying, I thought I was doing the right thing, doesn't cut it for criminal charges.
Like the Rodney King case. Was that federal?
Classic example of federal intervention under Title 18, Section 242, yeah, when local processes were seen as insufficient.
Okay. What about other liabilities? You mentioned officer-created danger.
Yes, that's an emerging and really scrutinized area. It holds officers accountable when their own negligent actions create or significantly increase the risk, potentially forcing the later use of force.
So their earlier mistakes led to the need for force.
Potentially, yes. The case Young v. City of Killeen illustrates this well. Officer Olson was found negligent in a whole series of actions. Bad radio use, dangerous car maneuver, not using backup right, giving confusing commands, having both suspects exit at once, abandoning cover.
Wow, a chain of errors.
Exactly. The court found these negligent pre-seizure actions basically stacked the deck, heightened the odds of a violent outcome, made the situation far more dangerous than it needed to be. It raises that important question. How much responsibility lies with the officer's conduct before the force itself for how things escalated shifts the focus earlier?
That's a big shift in thinking.
Yeah.
What about state-created danger? Is that similar?
Closely related, yeah. Also fairly new, rooted in older child abuse abandonment cases from '79. The legal bar is high for this one.
How high?
The plaintiff has to be part of a limited group. The state's conduct put them at substantial risk. The state consciously disregarded that risk, acted recklessly, and the conduct has to be conscious shocking. Really egregious stuff.
Okay. Any examples?
Several really poignant ones. White v. Rochford. Cops arrest a driver, leave his kids alone on the car on a busy highway. Court said that created danger.
Oh my gosh.
Knight v. Tedder. Officers separate an intoxicated woman from her husband, leave her to walk home alone in the cold. She got hypothermia, permanent brain damage.
Horrible.
Wood v. Ostrander. Trooper arrests driver, leaves female passenger stranded in a high-crime area at 2:30 a.m. She was sexually assaulted.
Just left her there.
Yeah. What's fascinating, legally speaking, is how these cases extend accountability for actions that indirectly lead to harm, even without direct force, creating or worsening danger through choices. It broadens the whole idea of an officer's duty of care.
So when courts do find force was unreasonable, what factors do they weigh for liability?
They look at several things. Officers can be held personally liable. Was there probable cause for the arrest in the first place? The Fourth Amendment limits force to objectively reasonable, Graham again. Reasonableness depends on the unique facts of that case. They evaluate the need for force. Was it truly necessary? And critically, were alternatives feasible? Were they considered?
Alternatives again.
Always. And finally, the extent of injury inflicted matters. Minor injuries might end up as a state tort suit, not necessarily a federal Section 1983 civil rights claim. The severity plays a role in the type of liability.
Given all these serious implications, criminal charges, lawsuits, the legal evolution, the community impact, it makes sense that policing is constantly trying to evolve, right? Emphasizing ways to prevent escalation, promoting collective responsibility.
Absolutely. That shift is palpable and, frankly, necessary. One really significant development, borrowed from fields like aviation and medicine where errors are catastrophic, is crew resource management, CRM.
Crew resource management in policing.
Yeah. The core idea is every crew member has an active voice during situations where human error can be devastating.
So empowering everyone on scene to speak up.
Exactly. The benefits are huge. It directly supports the duty to intervene. If one officer sees another going too far, they speak up. It fosters open communication, maintains accountability through collective oversight, and helps lessen individual emotional responses by sharing the cognitive load.
Moving from the lone wolf idea to team excellence.
Precisely. If we connect it to the bigger picture, it's about recognizing that multiple perspectives and shared responsibility lead to safer, better outcomes in these high-stress calls.
Have Texas done anything specific on this front?
Yes, there's been legislative action. House Bill 3712, passed in the 87th legislative session, prompted TCOE, the State Law Enforcement Commission, to publish model policies.
Model policies on what?
Key things: a clear duty to intervene and duty to report excessive force, a strict prohibition against chokeholds, and a fundamental duty to render aid to anyone injured during an encounter. These are big steps toward accountability, ethics, and prioritizing life.
Duty to intervene, no chokeholds, duty to render aid, important mandates.
Definitely. There's also a growing push for multidisciplinary scene response.
Meaning
everyone on scene fire, EMTs, police, hospital staff, lawyers, public works, even civilians and bystanders, needs to acknowledge and respect the concerns and expertise of all the other responders.
breaking down silos.
Exactly. Civilians and bystanders are often crucial information sources. It raises that question. How can police truly integrate all these different perspectives and expertise in high-stress, fast-moving situations, fostering real cooperation?
What about within the police ranks? Any changes there?
Yeah, an emphasis on leveraging junior officer knowledge. Newer recruits often have the absolute latest training, penal code updates, de-escalation, crisis intervention, firearms, driving tactics. Their fresh perspectives are invaluable alongside veteran experience.
Good point, combining new knowledge with experience.
Right, and acknowledging the diverse backgrounds officers bring. People come in with law degrees, corporate negotiation skills, sales experience, military combat tours, medical training, advanced degrees, experiences prison guards.
A wide range of skills.
Huge range. What's fascinating is recognizing how that prior experience outside policing brings valuable skills and perspectives to the force, enriching decision-making on the street.
That makes a lot of sense. What about preventing attacks on officers? Any proactive training there?
Big focus on recognizing pre-attack indicators, training officers to spot subtle cues that might signal an impending attack or someone about to flee.
Like what kind of cues?
Could be from cars. Why are they getting out? Why leave the door open? Escape route, weapon access. Suspicious talks between occupants. Body language is huge. Target glance. looking at an officer's weapon or weak spots, scanning for escape routes or backup, weird distance-based barriers, even a seemingly innocent felony stretch that might be a tactile scan.
Subtle stuff.
Very subtle. Even verbals stall utterances like, will the truth hurt me? Or trying to delay can signal deception or an imminent attack. The key takeaway they teach is simple. You can win.
Win.
Meaning, seeing and reacting to these pre-attack indicators gives you precious time to act first. Taking aggressive, decisive action early can often stop an attack before it even starts, maybe with just the threat of force, preventing the need for higher, more dangerous levels of force altogether. It's proactive safety through hyper-awareness and decisiveness. #outro.
Wow. We have covered a lot of ground here, a really deep dive into what use of force truly means for peace officers. We've hit the legal definitions, those landmark court cases like Graham and Garner setting the boundaries.
The foundation.
We dug into the intense psychological pressures, the spectrum of force options from presence up to deadly force, the critical pathways for accountability when things go wrong.
And how policing is evolving.
Right, the evolving nature emphasizing prevention, de-escalation, collective responsibility. Our goal through all this was really to provide you, our listener, with a clearer, more nuanced, hopefully more informed understanding of these incredibly complex, high-stakes decisions made in fractions of a second.
Yeah, and this deep dive, I think it really shows us that use of force, it's not just a physical act, is it? It's this profound intersection of law, psychology, human behavior, ethics, constantly being debated, constantly being refined.
Absolutely.
From those detailed definitions to the factors courts weigh, the internal struggles officers face under immense stress. It just highlights a field that's perpetually under scrutiny and always evolving. And it really leaves us, I think, with a critical question.
What's that?
How do we as a society ensure that officers are equipped not just with the tools, the gear, the rigorous training, but with the wisdom, the ethical compass, the self-control to make the right decision every single time in those fractions of a second that define their duty, their lives, and the lives of everyone they encounter?
That's a powerful question. Really makes you think about the immense responsibility that comes with that badge and the incredibly complex expectations we place on the people who wear it. Thank you for joining us on this deep dive. We hope you'll reflect on the depth, the nuance of these critical issues, understanding the clarity, the context. It's just vital for any informed discussion.